partner at Lowercarbon Capital, and I'll kick it off with introducing our panelists. Deirdre Zammit is MIT's Associate Director of Licensing, leading the team that evaluates, protects, and licenses MIT innovations in physical sciences created by MIT investigators, including MIT Lincoln Lab researchers. Deirdre's professional experience includes roles managing and licensing corporate, academic, and federal lab IP assets, with previous IP management and licensing positions at Lucent Technologies, Azure Systems, MGH, and the Naval Research Lab. Deirdre started her career as an engineer in the semiconductor industry and has held global product manager, market manager, and corporate BC positions in the industry. Next, Dylan O. Adams is a patent attorney at the law firm of Davis Wright Tremaine, LLP, and he helps companies protect their IP from early stage startups to Fortune 100 companies. His US and foreign patent experience spans robotics, software and hardware, mechanical devices, designs, and beyond. Didn't think I would use IP law and page turner in the same sentence, but your book kept me up on the red eye, and I'll really recommend it to anyone who wants a readable insider's guide to the patent process. Dylan has his bachelor's in biochemistry and molecular biology, his master's in electrical engineering and a JD, and his technical career spanned wireless, smartphones, robotics, digital signal processing, and computer networks. Professor Yet-Ming Chiang is Kyocera Professor in the Department of Material Science and Engineering at MIT. His research focuses primarily on advanced materials and their role in energy technologies. Professor Chang has co-founded 7 companies spun out of his lab at MIT, including 4 where he currently holds leadership positions. A123 Systems, which develops nanophosphate lithium-ion batteries. 24M Technologies, which is reinventing lithium-ion battery design and manufacturing. Form Energy, which develops long-duration grid storage. And Sublime Systems, whose decarbonized cement company, a decarbonized cement company whose CEO, Dr. Leah Ellis, we heard speak this morning. Professor Chang is a member of the NAE and really has too many other fellowships and honors than my 1 minute will allow. But he holds over 100 US patents and has published over 300 scientific articles. And this is really a star-studded group, so please help me welcome our panel today. It's my honor to set the stage for us today, and I really won't pull any punches on this one. The planet is literally on fire, and that is why most of you roll up your sleeves every single day. And I truly believe that the innovators who will save the day will go down in history, and that is the people in this room. And I'll posit that the fastest way we're going to do this is to invent products and services that are just better, cooler, cheaper than what we have today. And at Lowercarbon, we support inventors who do just that. We have over $2 billion under management, and we invest across what we see as the 3 pillars that will be needed to fix the planet. First, slashing no emissions across every sector of the economy, from transport to industry to food and ag and beyond. But while we're turning off the tap, we also clearly need to be bailing out the water. So pillar 2 is sucking greenhouse gases out of the atmosphere. We invest across engineered, natural, and other solutions. And even while we're doing these first 2 pillars, we need to buy more time for the people and the ecosystems they depend on that are going to be hit first and worst by climate change, whether that's coastal ecosystems, forest fire remediation, etc. At Lowercarbon, we are an early stage fund, a pre-seed and seed fund. So we love working with founders at the earliest stages and helping them figure out if a spin out from their technologies in one of these areas is the right path for them. And if it is, when to spin out. So I've been a friend of Yet and Leia's for a long time. So to concretize what we're talking about, pun intended, we'll use Sublime Systems as an example. The 3 things that we look for broadly as investors are, one is you've mapped the white space. Think about it as you understand the technology competitive landscape and marry that with also industry and customer needs. So in the case of Sublime, they understand there was no technology to make zero emissions cement with zero green premium. This may involve industry interviews, and a lot of them. what I'll say as my advice here is don't just believe what you have to write in that first paragraph of your paper to make it so that the thing that you're developing is the thing that's going to unlock a problem. That frame is what you write in an academic context, but let's question those assumptions and develop the, double click, if you will, into that paragraph. Number 2, does your solution have an unfair advantage? And it's better than the rest and the economics pencil out. And what I wrote for this one, and I think would agree with, was your, in this case, renewable powered ambient temperature electrochemical calcination just might do the trick. You don't have to know for sure that this is definitely 100% certain that it's going to work out, but you've gotten enough data and knowledge to hit an inflection point. I would say the major pillars of knowledge that you need to establish have been established, right? And in academia, you're helping trainees, students, and postdocs, right, expand the boundaries of new knowledge. And so you've gotten to an inflection point where the next stuff is basically a little bit more incremental. It's a little bit too big for my lab. Like, you've hit the place where it's ready to go fast and to take the next step. And number 3 that we're looking for is you're ready to sprint. You have a line of sight to the right team. So typical advice is to stay on non-dilutive dollars, for example, an ARPA-E grant, as long as possible, whether it's in academia or as a company. Venture capital is a style of money that's really right for when you're ready to go fast. And going fast means you have a full-time team, you're burning salary, you're ready to get going. So in summary, please don't, I meant to put my email address up here, please don't hesitate to drop me a line. My email is christina@lowercarboncapital.com. There's no such thing as too early to chat with us, and I look forward to collaborating with y'all. So, with that framing, I welcome our panelists who will present best practices and pitfalls for spinning out. Deirdre, the floor is yours.
Thank you, Christina, and it's a pleasure to be here today. It was suggested to me that I try to highlight a few best practices and things to consider when you are thinking about licensing a technology from a university, or if you're in a university, what you should consider when working with your technology transfer office in the university. As Christina mentioned, I manage a team at MIT that's responsible for managing the intellectual property of MIT and commercially licensing the intellectual property. So a lot of what I'm sharing today is from the perspective of my experience at MIT. Notwithstanding, I also have experience doing technology transfer out of a teaching hospital and the Naval Research Lab in Washington. So as far as best practices, if you're an investigator in a federal lab or a university, teaching hospital or comparable institution, if you're interested in a startup opportunity, or if someone of your trainees is interested in potential startup paths, talk to your technology transfer early so they have that on their radar screen. That might influence how they manage the intellectual property assets coming out of your laboratory. And technology transfer offices, as a general course of their business, are promoting the technologies from the institution. So if in the back of their mind they're thinking, okay, there might be a startup opportunity here, that might change how they communicate about the technology with other stakeholders that might be approaching the institution about the availability of different technologies. One of the reasons I say talk to your technology transfer office early is also relating to the patent prosecution process. There's various junctures when your institution is making decisions on whether or not they invest in patent protection, continue to invest in additional patent protection, including international patent applications. So if they can anticipate a potential startup opportunity and it seems viable, that may change how they invest in the patent portfolio as well. The next item I want to highlight is to ensure that you understand the policies and practices of your institution. As an example, at MIT, our researchers, if they're going to remain at MIT, there's a conflicts of interest policy that they must adhere to, where they could be advisors to a startup company or have consulting opportunities outside of MIT, but they cannot have an officer position in a startup company while staying at MIT, as an example. So I think it's important for people to understand their institution's policies, which may direct how they personally may be involved in a startup opportunity in the future, but then if you're not permitted to go with the startup 100% while staying at your institution, just planning for that so you can make sure you bring in the other resources that you need to fill the gap. I think also, the timing of things. At MIT, if we are engaging with graduate students, as an example, that are leaving MIT to create a startup, they're graduating, now their next venture is going to be a startup opportunity, we really want to make sure that those students graduate first, and then we talk to them about the startup opportunity. So just for your individual institutions, just understand that up front regarding the timing of things, just to make sure that your expectations matches the practice of your institution regarding when they can engage your team about perhaps license agreements or even an option agreement to later negotiate a license agreement to the intellectual property. And various technology licensing offices run differently. Within MIT, my office does not personally help teams incorporate, does not help them with business plans. There are a lot of other resources on campus that can support the teams, but some schools are different, some institutions are different where that's located in all one office. But notwithstanding, the technology licensing offices, if they don't offer that support directly, they can often make very good recommendations to you regarding programs in your local area or otherwise that can help you learn the things that you'll want to make sure you understand before investing significantly in a startup opportunity. As far as things to consider, I wouldn't call them pitfalls, but just things for you to consider as you are thinking about a startup opportunity for yourself. When you're developing technology, obviously you're obtaining funding to do your initial research. Depending on the source of that funding, there may be obligations tied to any intellectual property that's created with that funding. An example may be if you are at a university and you accept corporate funding, it's possible that that corporate sponsor may have certain options to take perhaps non-exclusive or even exclusive commercial license rights to those inventions that you create at your institution. So it's just something for you to consider that, if you're thinking of a potential path for a startup opportunity, do you have any corporate sponsors that invested in your research and have certain option rights to take commercial licenses? In some markets and applications, even if a sponsor maybe has a non-exclusive license right to use the technology created in your school, that may be okay. There still may be opportunity for the startup to have a very strong, viable business. At MIT, there are many startups that have been successful where their license rights from MIT were exclusive, but for a non-exclusive license that we granted to the corporate sponsor that initially funded that research. But then there may be some other market spaces where if the sponsor is a significant player in that field, it may be a bit more challenging for that startup company to raise venture capital, as an example, if they're not able to tell their potential investors that they have the exclusive rights to that technology. So I just raise it as a topic for you to consider, when you're initially thinking about getting that original funding to support your research. Next item, I just want to highlight, a company doesn't have the rights to commercially use a university or other institutions' intellectual property unless there's an agreement in place. I just highlight that because at MIT, we're very supportive of supporting startup opportunities that come out of MIT. Notwithstanding, from time to time, there really may be a technology that was developed at MIT that might not be best commercially developed and exploited through a startup company, but rather through an established player in the market. So just want to make sure that everyone understands that rights are not conveyed to a company unless there's an actual agreement in place with the school or the owner of the intellectual property assets. And then I just want to highlight that everyone should really consider their local technology transfer offices as a collaborator with them in the commercialization process. Ultimately, if the technology is licensed to an established company or is licensed to a startup company, the technology licensing offices of universities and other nonprofit entities really is focused on getting the technology diligently developed and commercialized so it's made available to the public. So really think of the technology licensing office as your partner in getting that mission completed. Also, when license agreements are signed, if everything goes well, license agreements can last for decades. So just think of the technology licensing office and the owner of your intellectual property assets that you've licensed as your long-term partner. Especially if things are not going well for the business, the company may have to come back to the licensor, the university, and say, you know what, we're not hitting our diligence milestones, things are not panning out as we hoped. Can we talk to you about adjusting our agreement terms? More often than not, the university is going to agree and try to work with the school, with the startup or the licensee, if that party is diligently showing efforts to commercialize the technology. But it's always best to have a long relationship, a well-established relationship with the tech transfer office before you have to come to the technology transfer office for that type of request. So I really just want to emphasize that technology transfer offices, they are service organizations for the university with the mission of getting the technologies diligently developed and commercialized. So consider them a true partner in your commercialization interests. Thank you.
Excellent, thank you. And Christina, thanks for the great introduction. I really appreciate it. I'm Dylan Adams. I'm a patent attorney, and my practice is helping companies of all sizes protect their ideas and inventions. And I work with all the way from garage inventors to startups to Shark Tank companies to Fortune 100 companies. But I have a lot of experience with early stage companies, especially ARPA-E companies, and I have a lot of clients who have worked through that process. So a great ARPA-E success story of one of my clients, they started out as a small two-person team at a tiny incubator, and 10 years later now they have over 600 employees. They've deployed their product in countries all around the world, and we've grown them from having one single provisional application to having hundreds of patent assets, and they recently closed a well over $100 million round. So I understand the life cycle of startups and how to grow and scale patent portfolios. Part of what I have to do is I have to understand technology as well, if not better, than my clients. So that's why I have background in electrical engineering and biochemistry and molecular biology. So the main pitfalls when it comes to patents that you want to avoid is address ownerships early on, okay? Also, do not file patent applications too early, but at the same time, don't file patent applications too late. And that dovetails really well into my best practices. So when it comes to ownership issues, so by default, the inventors of the technology own the patent rights in things, okay? And so just because somebody is an employee, just because somebody is a founder, just because somebody is a professor at a university does not by default mean that those entities own the patent rights. But what typically happens is that the first day you start working or the first day you're employed, right, you're gonna be signing a contract that says, I hereby assign my patent rights to the company or to the university. And so you want to pull those contracts out now and determine what are the ownership issues. Does the university own things? What do they own? Is this a side project that doesn't fall under that blanket of what the company or university would own? And then what about inventors who are not part of that company or university team? Who do they have assignment obligations to? And do they even have assignment obligations to your company? Do you have those agreements in place if they're outside contractors and things like that? Okay, so to the next point. We live in a first-to-file system. So priority with patents is based on who files their patent application first. It is not who invents first. And intuitively, you would think that, okay, I invent something, I want to go out, I want to file as soon as possible because I want to get that early priority date. That's what's really, really important. But when it comes to business decisions, it's counterintuitive. It's actually typically a better business decision to wait as long as possible to file patent applications. And there are two main reasons for this. One is a budget thing. So what a lot of people don't realize is when you file your first patent application, you are opening yourself up and sort of obligating yourself to these downstream costs that are absurdly expensive. A lot of times you are not going to be ready to invest the capital you need to invest and make the choices you need to make if you start this patent process too early, okay? Another thing is that patentability tends to be in the details of how something is done. So you may have a great idea and you want to go and patent that, but that typically isn't going to be patentable. It's going to be in the details of how that is done, right? The more time you can take to develop the how and the what, then you're going to have stronger patent applications. So if I'm telling you to wait and file patent applications as long as possible, when do you want to file them, right? There are 4 times that I typically tell clients to file patent applications. The first 3 relate to forfeiting patent rights. So unless you file a patent application first, you will start losing patent rights upon a first public disclosure, public use, or offer for sale, okay? So obviously, you want to file a first patent application before public disclosures, public use, or offer for sale, so you don't completely start forfeiting your patent rights, okay? The other one is when you are talking to investors. Now, talking to investors, that is not going to be something that's going to be forfeiting patent rights a lot of times. These are going to be confidential discussions, and so it's not going to be forfeiting patent rights, but it's a lot better for your pitch. You can go in, you can say you're patent pending, you have patent assets, really improve the optics of that. And as I hope you know, don't try to ask investors to sign NDAs. They are going to be insulted by that and probably not going to want to work with you. Better to go in, say you're patent pending, then you can be open about the technology, tell them what you're doing, and you have an early priority date. So that's kind of the basic 5-minute rundown about patents. Look forward to your additional questions during the rest of the session. Thank you.
All right, so let's see. So it's great to follow a patent attorney because I've been at a university long enough and patented enough times that I like to say to my friends, I know how to play a patent attorney on TV, right? And but I also know when to get professional help. And so when they start talking about 102 versus 103 rejections, I'm thinking, oh, now which one's which? One of them is called anticipation, the other is called obviousness. And well, if those words already confuse you, that's why you need professional help, right? But so let's see. Let me go forward to. Oh, this is just a bio side. I got it in there. Okay. So on the left-hand side, I hope you can see. So I'm really speaking to the university entrepreneurs here, and who have or are thinking about or think you might someday spin out a company. And so, what are some of the best practices that I've learned over time? And the first one there is that what can precede a license is an option to that license. And so my advice is always sign the option first. Right? And these options are typically exclusive options, meaning you're the only entity that has that option. And it should be for small money. And you say, okay, well, how much should it be for? Well, I think I have like $25 in my pocket here, 24. That's about right. Now, Deirdre's sitting here, and now, but the reason I say that is because there are a lot of other costs associated with having signed that option. If it's a place like MIT, as soon as you sign that option, you start paying for the patent prosecution costs. That will far outstrip whatever the option fee might be. But the typical option fee is something under $5,000. Okay? But it gives you, in most cases, there's a period, but typically it might give you a year to figure out a few things. Number one, do you need that IP? Okay? So if you proceed to a full license and all the costs that go along with it, and then later decide that, well, actually, I didn't need that IP, and it might be your own IP you don't need, right? So there's a reason to wait and see what you actually need. There are a few other reasons, but let me go to the second one. Negotiating. So if you're sitting here saying, gee, I never thought of that issue, right? That makes sense, but I wouldn't have thought of that. But that's why you need someone who can help you negotiate. And so typically, if you're someone like me or a graduate student or a postdoc, often you're the inventor on the IP you're trying to license for the Spinout. And so you have this inherent conflict of interest. You actually, through the university, would benefit from that license. So in a way, you're almost negotiating against yourself. Right? So that's one of the reasons, but there are others where you simply may not have the experience, so finding someone to lead your negotiation is a really important thing in my view. And a lot of pitfalls. There's so many pitfalls that they asked us to limit it to 3. There's so many ways to fail. Find a negotiator. Then the last one here is specific to royalty terms, but it really it applies across the license. If you're starting a very early stage company, you probably don't know exactly what the business model is going to be yet. You don't know how you're going to make money. You may not even know which particular industry you're going to go into and what the margins are. So if you don't know what your gross margins are, how can you really know what royalty you'll be able to afford to pay and still have a good business? So that's the reason to really think about what the business is going to be. And now I'm going to return to something that Deirdre brought up, which is that licenses do get negotiated. And so I've had the experience where once the business became clear, and it became clear how small those margins were going to be, we looked at the royalties and said, well, that's certainly not going to work for us. And that was the basis for a renegotiation. Your TLO doesn't want you to go out of business. They want you to succeed. Another instance, for instance, we negotiated a license that had a sliding scale for the royalty, with a floor and a ceiling, but the sliding scale was tied to what the gross margin of the business was going to be. So there's some practices here. Right? My second point over here, you're not trying to win, right? So I wanted to read to you MIT's Technology Licensing Office mission statement. To move innovations and discoveries from the lab to the marketplace for the benefit of the public and to amplify MIT's global impact. That's a wonderful altruistic statement. What I want to point out there is that it does not say to make money. Right? Nowhere in there does it say to make money. And so when, I feel like over a long period of time, I felt like my mission and MIT's mission has been well aligned. Now I want to read to you Stanford's mission statement. Okay? To promote the transfer of Stanford technology for society's use and benefit. Wow, that sounds wonderful. But part 2, while generating unrestricted income to support research and education. So there you have it. That's the difference between MIT and Stanford. Right? That's why I'm at MIT. So at Stanford, benefiting society is great, but you got to make money at it. Show us how you can make money at it. Right? I'm kidding. I have many friends at Stanford. Okay, let me go to the last one here. One of the terms in your licensing agreement is the field of use. Right? And so what specifically can you attack? So, very often an invention might be broad enough that it can address a number of different businesses. And you say, okay, now you have to select. And my advice there is to think very broadly. A year or two from now, you might be thinking about, initially I didn't think that we could do that, but now I believe that we can do that. And so broader fields of use are always better. I think that the breadth of the field of use is not linearly correlated to the cost of the license. Right? I'm looking at Deirdre. So broader fields of use are better. Right? So I'm going to just go and finish with this one thing. All right. So a typical licensing agreement has 4 key terms. Equity, how much of the company the institution will own. Royalties, right, we understand those. Upfront payment, upon signing the license, how much do you pay? Milestone payments, when you reach certain milestones in your development as a business, how much do you pay? So I've often likened this to an air mattress with 4 corners. Right? The 4 corners, these 4 terms. And in my experience negotiating these licenses, it's like an air mattress with a constant pressure. If you push down on one term, they tend to pop up on the others, right? And so this is this is how it often works. And so your job is to lower the pressure in that air mattress overall, which is what these people are doing here. Okay, so with that, I'm going to stop and hand it back to Christina. Thank you.
Okay, here's a question. U.S. manufacturing is a priority for ARPA-E. How do the U.S. manufacturing requirements affect negotiation of licensing deals?
So that is something that universities and others that take ARPA-E funding are required to place in their license agreements. So when MIT does a license agreement with a company for intellectual property assets that were funded by ARPA-E that have that U.S. manufacturing requirement, we must put those in our license agreements, obligating our licensee to substantially manufacture in the U.S., regardless of whether or not it's exclusive or non-exclusive license. Historically, the U.S. government funding U.S. manufacturing requirements have been substantially manufactured in the U.S. if it's an exclusive license, but ARPA-E, among other agencies more recently, are adopting a requirement that there be U.S. manufacturing, even if it is a non-exclusive license. So it's something that the owner of the intellectual property that received the funding from that federal agency must pass on to the company that's taking the commercial license rights to the intellectual property.
Maybe I can speak a little to what the issues are. And it's a little bit different, I think, pre-IRA and now. So first of all, I would like to manufacture in the U.S. I think probably everybody in this room feels that way. The rub is when the U.S. is a difficult place to do that manufacturing. And so if, for instance, in the early days of lithium-ion, nobody had the expertise here in the U.S. doing any manufacturing. We didn't have the supply chain. You couldn't hire battery engineers who knew how to run a battery factory. And so I think then it was those kind of that kind of requirement can be difficult, and I'm sure there's still some sectors there. But the thing that I would point to is that is part of the ARPA-E agreement, but you can also ask for a waiver. And so, depending on circumstances. I want to give one more example of where this has become an issue in my own experience. So if you have a company for whom the main business model is licensing, well, you're going to license to another company, but here again, those are your customers, potential licensees. Are they in the U.S. or not? What if the industry that you're addressing, your licensees are all or mostly foreign entities? Then if you were to strictly limit yourself to U.S. licensing, you have a much, much smaller pool. Your addressable market can shrink from X to 0. Literally, right? There may be nobody in the U.S. you can license to. And so in that case, that's it really, I look at it exactly in that way. That requirement can limit your addressable market. And so again, love to manufacture in the U.S., but that's another case in which you might have to, for instance, go negotiate a waiver with DOE.
Sustainable cement is a good example. Cement is heavy, like many commodities, in particular want to make it really close to using it. Building on that, how do y'all think about building an international IP strategy?
Yeah, I can probably talk to that. So as far as international goes, one of the biggest things to understand is that there's no such thing as an international patent. You have to file in each specific jurisdiction, which as you can imagine gets extremely expensive. There are some regional patent offices like the European Patent Office, but even in the end there, you still have to validate, as in pay them a bunch of money in each country you want to validate the issued patent in. So you have to be very, very selective with growing foreign patent assets. And for me, what I always think of is, do you actually have customers there? Do you have strategic partners there? Do your investors care about these companies? Do you do manufacturing there? Ideally, and it kind of dovetails in what I was saying about delaying the patent process, you can have the opportunity to delay when you have to make these decisions about expensive foreign filing when your business actually knows these situations, right? So it's better to wait until you know, hey, we have investors in these countries, our investors care about these countries, they're going to fit the bill for foreign protection in these countries. So you have to be very, very selective about it because foreign is very expensive.
Another question here. How do you think about terms around exclusivity of the patent you're going to license? What do owners of IP look for in a licensee to be comfortable granting exclusive license?
I'll take that one. It's a combination of team, like, do they have the business and technical skills to move the technology forward, and the resources available to them. Do they have not only capital, but, is there a supply chain that they can eventually gain access to? Are there manufacturing facilities that either they have or it's contemplated they can develop them themselves or have access to them? And then, overall, the market fit. Does the technology fit well with their proposed market application? Like, is there a viable business opportunity, a business plan that the team is presenting to us?
So let's role play. I'm on the other side of the table.
Oh, no.
I'm going to say to Deirdre that if you don't give me an exclusive option or license, there's no way that I can start this up. No way that I can raise the capital that I need. She actually said that earlier herself. Right? So give me the exclusive license. And what TLO will do is put in a term that, well, you have to demonstrate that you have all those characteristics that Deirdre just pointed to. And we're going to hold your feet to that fire by making one of the terms in the license that you have to raise a certain amount of capital. And so there's a mechanism. And so I think startups start out treading water if they don't have an exclusive, at least access to an exclusive license. Because you are going to go raise capital from folks like Christina. And if, what's the difference between exclusive and non-exclusive? Non-exclusive means that you can go put in years of effort, and that other licensee can then step in once you've shown that everything works. Who wants to fund that? And so that's why exclusive is important.
A little bit building on that, could y'all expand on negotiation strategies with TLOs? So when you work with your negotiator that you send in, you've been on that side of the table many times. How do you think about back row strategies, trade-offs on individual items in that mattress?
I would feel freer to speak if Deirdre wasn't here.
So, just so you guys know, Yet and I have never negotiated with each other. And as a professor, he's not actually committed to negotiating with MIT.
Yeah. I will say that, all of the, let's say, points that I would negotiate on aren't things that I came up with myself. It's because I worked with good business people who were good negotiators, and not just not good negotiators in the sense of being combative people, but because they really understood what the important points were, what the company was going to need. And so, I would say, for example, someone in an academic environment who hasn't done a startup before probably doesn't realize how much additional capital it is. Right? And so, when you look at your license, and so there's a sense that, here's this crown jewel, and all we need is that crown jewel, and everything else is downhill from that. It's actually, it's never true. It's your own patent. You start thinking it's a crown jewel, and after a while, it gets smaller and smaller. And so there are going to be additional inventions. There's going to be a ton of capital that needs to be raised. At the end of the day, if you're successful, how important is this first license? That's the question you have to ask. And so that's also why you have a conflict, because if you're an inventor, you think it's great, right? And that's why you did it. But your experienced business partner may have a much longer-term perspective on that and what it takes to be successful.
And when Yet had his slide up there that showed the equity and the other financial consideration components, when licensing offices are negotiating with startups, I mean, startups need to use their money in the earliest years developing their company and developing the technology and moving technology forward. So that's why technology transfer offices, on behalf of their institutions, take equity, because it's a deferred compensation. And then, I think for the startup company to, work with the the technology licensing office, coming up with, a path for that kind of deferred compensation, like royalty rates is a good example, because the university only gets consideration when the company's doing well, selling the product.
Leads into this budgeting question, which I'll direct to Dylan, but open to everyone. How should you budget for IP costs? What are the typical costs for applications and filing fees?
Yeah, that's really important. And so it probably helps to kind of start with a bit of the patent process where the costs come into that. One of the guiding things, especially in the beginning, is to keep patent costs as low as possible in the beginning while maintaining as many options as you can. And so typically the best way for startups to begin the patent process is by filing what's called a provisional patent application. Provisional patent applications are just placeholders. They only last for 1 year. They automatically expire at the end of that year. And then you have to file the full and expensive non-provisional patent application, and you have to think about foreign filings as well at that 1 year anniversary. Now with a provisional application, you can do the platinum attorney drafted version. That's going to cost you $15,000 to $20,000, but that doesn't make a lot of sense for really any startups. And the best way that I like to work with startups in doing provisional applications is leverage their experience with the technology. Have them draft a detailed invention disclosure. I can scrub that, make sure there's no limiting language, and get a provisional application on file based on that, and get substantially more ROI than having to spend $15,000 to $20,000 by filing that sort of provisional application. File the provisional application, then a year from then you have to think about filing the US non-provisional. That's going to probably be in the $15,000 to $20,000 range. An attorney has to draft that one. It is really important that you work with an attorney at the non-provisional stage. You also need to think about foreign filings. Your deadline to select that is also at that year anniversary from when you filed the provisional application. The best way to do that is by filing what's called a PCT application. Think of it as like patent pending effectively worldwide. It gives you another 18 months to decide which countries that you want to go into. That's going to be around $5,000 to $5,500. So then, as far as the US patent process, you filed the expensive non-provisional patent application. It waits in line at the USPTO for 1 to 3 years before examination begins. And it begins a negotiation with the examiner. Think of it like haggling, like in Pawn Stars or American Pickers. It's a natural part of the process. That's how you get the broadest claim scope possible for your patent. You have to go back and forth with the examiner, and going back and forth and using your attorney, it's going to be around $3,000 to $7,000 for each response. Sometimes it's quick, sometimes it goes back and forth for years. Hopefully the examiner is convinced that what you have is new and non-obvious with a priority, allows the case, you pay an issue fee, and then your application issues as a patent. On the foreign side, so you filed your provisional. A year from that, you file your PCT application. That gives you 18 months to decide which specific countries you want to go into. Again, you have to be very, very selective. Just the initial filings are going to be $3,000 to $10,000 per country. And then over time in each jurisdiction, typically what I say is in English-speaking countries, assume it's going to be at least $25,000 to $30,000 over time. Non-English-speaking countries and regions like the European Union, that can be $35,000 to $40,000 each country or region over time. So it's really, really expensive.
I'm going to take this opportunity to, on this cost issue, return to a point that Dylan raised earlier. I think, it's really weird for an attorney to be saying to you, you should defer as long as possible before I start billing you.
Yeah.
That's what he says. So wait as long as possible for filing. I've had the experience of both. So first of all, after that first filing, it's 18 months before it gets published. Now, what that means is that whatever your competition is filing, you won't know about it until 18 months after they publish. So I've had the experience of after those 18 months and your ours publishes and someone else looking at the calendar and saying, wow, it's a really good thing that we filed that when we did and didn't wait a month because we got in ahead of it. And I've also had the converse experience by saying, man, I wish I'd been a little more on the ball and filed a month earlier, because look at this piece of art that came out a month before ours. So that makes me just paranoid as hell. And so what he's recommending of waiting as long as you can I could never do that. Right? Waiting as long as you can before you file. My recommendation is kind of to factor that into it, and just when you're building your company, just plan on developing a really big war chest for IP, to pay for IP, so you can hire guys like him. And, but that's my approach. I cannot, constitutionally, I cannot sit there and say, I'm just gonna wait. And I think this is a really important idea to file on, but I'm just gonna wait as long as I can. I could never do that.
And I'll kind of add to that, and it's always going to be a business decision. You want to file early, and I've had this where you come into examination and we find that literally I've had this where somebody filed a day before we filed. But one of the things with patents that's important to understand, it's not just a binary thing where you have a patent and you don't. You can have a really broad patent that covers a lot of different variations. You can have one that is really narrow and really specific that almost nobody can infringe because it's so narrow. And a lot of times, and especially in this case that I was talking about, where there was prior art that was very similar to our invention, it just meant that the scope of the patent that we ended up getting was a bit more narrow. It doesn't mean that you're not going to be able to get a patent. There's typically ways to navigate around that prior art, even if it's very simple. And at least in my experience, it's more of an existential issue for startups to have to incur costs or make big decisions when it comes to IP and not appropriately invest by filing too early than the issues with the prior art, which, it does happen, but a lot of times it just means, your patent isn't going to be as broad. But to be honest, a lot of people, whether they be investors or whether they're other folks, don't understand what broad versus narrow is in patents, and it doesn't tend to make that much of a difference. That's just my experience.
You can see why you can have a lot of discussion about this point. I mean, I don't fundamentally disagree with Dylan at all, but these are the tensions that you have when you're trying to solve this problem.
Yeah, it's very bespoke work. It's not a cookie cutter thing where this is the right thing to do for every company. It depends on your business model, where your technology is, what your goals are in the next month, 6 months, year. What sort of how are you going to fund the company? And that's what I enjoy, at least about my practice. It's bespoke work tailored to each company, their difficulties and their budget concerns. That's what makes it fun.
When would y'all recommend spinning out a company versus licensing the tech to an existing company?
I have a really easy answer to that. The parents always know what's best for the baby. And so I think really the only reason to go for the license would be if you really don't want to do a company. To me, that's really the circumstance in which. I'm sure there are other examples, but in other ways, if this is what you want to do, this is what you're into, why would you miss out on the really fun part, which is to go start a company and try to make it real, and you're going to be one of the team that knows best how to do that.
I'd say there's some technologies that might be a better fit for established companies versus startups. I mean, as Yet says, the investigators that develop the technology, those are the people you want to move the technology forward, particularly if it's a startup company where it's a platform technology. I mean, MIT has a lot of intellectual property assets that are improvements on existing, well-established industries. So very often those types of technologies are really good fits for established companies, just because a startup wouldn't even be built around something that's an improvement on a very well-established technology, as an example.
Yeah, I agree, but we're on the ARPA-E stage.
Sure.
ARPA-E is never going to fund a project like that.
Apparently, Cornell University, according to this queue, has fast-tracked generalized licensing negotiation pathway where most of the negotiating can be done through an online platform and are transparent. What does the panel think about universities making their licensing terms more transparent?
So I'll speak about MIT. We have a few technologies where we call it like ready to sign, where they're non-exclusive licenses. As long as you're a party that we can give a license to, pay the fee, and then we'll license the technology to you. But every technology is very different. Like, I can't even imagine MIT supporting something like that.
What are the pros and cons of licensing versus owning a patent outright? Not quite sure where this question is coming from, but I do know that some startups just go ahead and buy the IP.
A lot of universities actually aren't really in a position to sell the IP assets. Like, MIT won't sell intellectual property assets, but we will exclusively license them to a company, which is comparable but not the same.
I have heard of instances in which MIT thinks the IP is so worthless that if you want to take title to it, be our guest. So that's another way to own your own IP. Now, okay, I have to finish the story. This is a very shrewd faculty member, and what he actually did was to do MIT TLO into, this is a long time ago, into believing that it was essentially worthless. And then he took it and went ahead and started a company. That's all.
Hasn't been turned out yet.
No names. No longer at MIT.
Maybe I'll ask one more question and then ask the panelists to provide any concluding remarks. But thought this was also interesting. Can you share your point of view on technologies that are co-invented between two or more institutions? There may or may not be inter-institutional agreements in place, but how do you approach commercialization?
When MIT has inventions co-owned with another party, very often there is an agreement between those co-owners called a joint invention agreement or an interinstitutional agreement, where typically that agreement outlines that one party is going to be in the lead for patent prosecution activity and then also marketing and commercial licensing activity. And should there be commercial licensing where revenue starts coming in, the party in the lead will share the revenue proceeds with the joint owner. I mean, that's how it usually works.
And it's best to have standing agreements, because if you don't, then what happens is your technology licensing office says, oh, okay, now I have a headache, because I have to go ahead and negotiate another agreement before I can actually execute the license.
Oh, any final words from any of our panel?
I think I might just say real quickly, jump on these things early. It's better to figure these things out and put together a plan. At least on the patent legal side, a lot of times that can be free or extremely inexpensive. It's really cheap insurance, especially things with ownership issues. I've seen a lot of companies essentially tanked and they're radioactive to investors because they have this one person who's an inventor who never had any assignment obligation to the company or to a university. They go off and, so there's no true ownership of the IP rights, and investors hate that stuff. So figure that stuff out early, get a plan together, get together early.
I would say there's a lot of people out there to get information from. Don't learn for the first time by making mistakes. There are other people who have executed licenses. I'd be happy to share them with you. Your investors will have seen a lot of licenses. And so your investors are great resources. Again, maybe they can't show you exactly the license, but they can tell you what's market. So earlier I made the point that you're not trying to necessarily win. You're more likely to be aligned with your TLO. So given MIT's mission statement, why are they charging us anything for a license? Why aren't they just giving it just for free? Because we're going to go out there and better the world. And I have this picture that all these licensing offices get together in a cocktail party and they're talking to each other. And they have to be able to hold their head up and say, "Well, I got a better deal." They're comparing deals. So there's something that's sort of market in this business, and that may be. In any case, I'm going off track. Talk to other people.
I mean, just for clarification, when universities do bring money in, there's Bayh-Dole regulations that kicked in around 1980, where the university is actually obligated to share those revenue proceeds with the investigators. So the money that comes in from licensing, we're required to share part of those revenues with the actual inventors, regardless of whether or not they stay at the school. And then a good portion of the money goes back into research at the university. So it's not, it's all going back to either the individual contributors, the laboratories that developed the technology originally. So it's fueling the R&D cycle.
Good point.
I understand we're at coffee break, so please come up and say hi and have coffee with us. And with that, let's thank our speakers.